Hello, this is Matt on the Moon Lambeau channel. Representative Tom Emmer says that it's time to hold Gary Gensler accountable for the way in which he has been, quote-unquote, leading the SEC. Use the term leading a bit loosely there. Take a look at this quote from him. This is a tweet. Watch me hold Gary Gensler accountable for how his leadership could devastate American crypto investors. Oh, yes, indeed. So he in a conversation today had some things to say about the way that the SEC is approaching crypto, and had some very serious and pointed questions for Chairman Gensler. And all of this is highly impactful to us as XRP holders. Obviously, we've been taking the brunt of the action against the SEC for the last year. That's quite obvious. And certainly leading the charge against the nonsense that the SEC has brought upon us. We didn't ask for this mission, but hey, we're all here, and we've certainly rallied together. So I want to share with you what Representative Tom Emmer had to say, because it was just a breath of fresh air seeing somebody in politics take it to him and ask the hard questions and give the honest answers. And I want to share with you my thoughts on this. But at the outset here, I do want to be clear that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who makes YouTube videos about crypto-related topics purely as a hobby, just for fun. That is all that's going on here. And if I could first highlight this, and yes, I can, because it's my channel, damn it, and I do what I want. This is cool. Attorney John Deaton, who of course is the attorney who is now allowed to participate in the SEC versus Ripple case. He's got quite a few people he's representing here. Look at this tweet from Attorney John Deaton. Over 25,000 XRP holders now have Amici Curiae status. 25,617 and growing. So I just thought that'd be a nice thing to start the video off with. So understand, there are tens of thousands of people frankly upset enough with what the SEC has done that they're taking a proactive stance by participating here, and there are many, many, many more because look, there's 3.4 million XRP accounts on the planet, so safe to say millions of humans that hold XRP. This is big. This is absolutely big, which is why the way that Gary Gensler's approaching this is just so highly consequential. It's incredible to see so many people, bravely fighting back here. And then there was this also here on this topic here. Somebody asked Attorney Jeremy Hogan, who of course runs the popular YouTube channel Legal Briefs, what is the difference between Amica, or I think isn't it Amici status? He wrote Amica, isn't it Amici status that was granted, and the motion to intervene, which was denied? Or if you have a link to another tweet, if you discussed it already. And so he's talking about there is John Deaton, his initial filing was a request to participate within the case to actually intervene, and there are legal implications with that term, intervene. And so that was actually denied, but he was granted, I believe it was actually Amici status. Maybe I'm mistaken. This guy wrote Amica status. That doesn't sound right to me. But there are different legal implications, and Jeremy Hogan actually cleared this up here, because I'm sure plenty of you there listening are wondering this as well. The denied motion would have made Deaton et al. Actual parties, and he could have served a discovery and asked questions at depositions, etc. And amicus is limited to basically the filing of legal briefs and a couple of other things. And so there you go. Now we have clarity. And by the way, worth mentioning this also, Representative Tom Emmer, very pro Ripple, very pro XRP. I'm not going to read this article, but just to highlight the points so you understand his background. This is an article from Cointelegraph, August 21st, 2020, of course, several months before the SEC legally attacked Ripple. The headline reads, XRP is not a security, argues U.S. Congressman Tom Emmer. So he's all on board the XRP train in that regard. And so, and I actually took some notes here, because I transcribed a little bit of this also. And so Representative Tom Emmer points out that over 55 million Americans have purchased cryptocurrencies. That's about 16% of Americans, which is interesting because it's estimated that only 3% of humans on the planet have ever purchased any crypto. So this means that although American citizens have been relatively quick to adopt this asset class, relative to any other area on the planet. America is still one of the worst countries on the planet in terms of offering regulatory clarity. And Mr. Emmer points out that Gary Gensler has stated he believes that most cryptocurrencies are securities. Now, the truth is that no cryptocurrency on the planet is a security. Zero. None of them. What makes something a security is the transaction itself based on the totality of the situation. It's based on specific facts and circumstances as covered by the Howey test. There is nothing about the nature of the existence of any crypto on the planet that makes it a security. And to drive this point home, imagine XRP were created, just as it actually happened in real life, but imagine XRP were created, but then never used by anyone. Would it be a security? Of course not. And Mr. Emmer says he believes that most cryptocurrencies are commodities or currencies. So whether they are or aren't commodities or currencies, I'm saying what it definitely is not for sure. There's nothing about the nature of it existing, any cryptocurrency, zero of them, that makes it a security. That's why if you go back and look at the Howey test, it has to do with oranges and orange groves and land and a number of other things, but there was no claim that oranges themselves were securities, because that would be stupid. S-T-O-O-P-I-D, stupid. And so then he went on to ask several questions, Tom Emmer did, of Gary Gensler here. And this was at this is an official House hearing, by the way. So it's the House Committee of Financial Services. This is where this hearing took place. It was all virtual, as everything is done these days, of course. And so he asked the following. Look, if someone issues a token and agrees with Gary that their token is a security, and they want to register it with the SEC, can they trade it on the New York Stock Exchange or NASDAQ? That's the question. Can they do that? And Gary responded that it would be up to the policy of the New York Stock Exchange or NASDAQ, but he says such a situation has never occurred. And so, look, this is kind of a dodge, a bit of a dodge. Emmer responds that the answer to his question is no, and here's why. Without an IPO, the cryptocurrency could not be traded on the New York Stock Exchange or NASDAQ, because buyers of a security, even if it's a registered security, so it's all legal, everything's good, it's scale of 1 to 10, 2 thumbs up from a legal perspective. If it's not something that's publicly traded, you need to be an accredited investor, and that's a very high threshold. So you're chopping out almost 100% of the potential market in this case, because in the United States, you need to be earning, I think the number is, it's either 200 or two. I always forget this. It's either 200,000 or 250,000 per year. And I think you need to have made that for the 2 previous years and are expecting to make that for the current year, the 3rd year. Or you need to have a net worth of at least $1 million. So it's almost zero Americans, almost none of them. So basically the opportunity presented here, and because you know what Gary's stance is surrounding all this, the opportunity that you've been afforded to achieve life-changing wealth, he doesn't think you should have it. He thinks that it should be gone. This is all illegal and nonsense. That's why, again, I'm so thankful that there are some out there in the world of politics that are actually taking him on. And then there's the next question. Can a broker-dealer like Charles Schwab deal in a digital asset that has gone through SEC registration? In other words, would they be able to deal in them and custody them, these cryptocurrencies? And so Gary Gensler, again, he sidesteps the question and says there are challenges with custody, effectively because someone could own crypto but not have possession of the private keys themselves. And so Emmer then answers the question for Gensler again, because he didn't answer the question again, and the answer, of course, is no. Registering a cryptocurrency with the SEC puts barriers in place, and broker-dealers like Charles Schwab would not be able to custody it. So again, it's just as outrageous as the first question, which is why I've always had a big problem with this. The idea that government knows best, I have a problem with. If people make poor decisions, then let them make poor decisions so they can learn from their mistakes and grow as a human. But don't take away my financial opportunity because you say that you're protecting me because I'm not an idiot and I'd like to be able to take on this risk. And even if things go south, then it's still my fault. I don't need daddy SEC to come in here and protect me from myself. It's just offensive, the idea that you know better than me how my funds should be allocated. But that's the stance that the government has taken here. I always find that offensive. And then there was this. Here's a quote from Representative Tom Emmer. Oh, and I love this. I've been wondering about this one for some time. I transcribed this, so check this out. Earlier today, you used the term stable value coins. There is no such thing. Value is a term that you put in there. They are stable coins. And so I heard him say that. I was like, yes, somebody finally told him. This is the first time I've ever seen, anyway, somebody call him out for that nonsense. Now, unfortunately, Emmer didn't ask why Gary created this new term stable value coin, which doesn't exist. It's just stable coins. So we still don't have the answer. I haven't seen that asked or answered anywhere. If anybody has, please let me know. As far to my knowledge, that hasn't. So I was glad to see it, but just one more step. I just want to know why, because in his mind, is there some sort of legal distinction? And if not, if it doesn't create some sort of legal distinction in Gary's eyes, then why add additionally confusing language? Because nobody uses the term. It's just like he's trying to start a trend or something. Gary, I'm sorry, no offense, but you ain't cool enough to start a new trend. I'm just telling you. And so then Emmer went on to note that there are about 100 cryptocurrencies with a $1 billion or more market cap. And he asked what happens to the investors if the SEC declares one of those tokens to be a security. Well, we know the truth, don't we, as XRP holders? Because we already saw this play out with XRP in December of last year. Investors were harmed and billions of dollars of market cap disappeared. Like Kaiser shows, it's just gone. It's just gone. Gary's answer was extremely out of line with reality, though. He says that if the coin were to be registered as a security, that investors would get the benefits and protections that securities law offers. Yes, that was his response to this question. He noted that a primary benefit would be protection against fraud. So that's a primary benefit of this registration. Now, of course, apply that thought process to what's happening with Ripple and XRP. Because, of course, there were no claims of fraud against Ripple in the case of XRP. So there is no upside here. So again, he's saying the benefit, you got to register. You got to register because there could be fraud, and this protects investors against fraud. But then again, here there's not even an allegation of fraud, so really it just harmed investors. Isn't that right, Mr. Gensler? And so here's how Mr. Emmer responded, and this is a quote. I transcribed this one also. Chair Gensler, actually, what will happen under that scenario is the value of the token will plummet, and retail investors, the very people you are supposed to protect, will not be able to trade in it. So I guess where I'm going with this is if there is no path for them to be traded anywhere, wouldn't investors be hurt by your enforcement actions? And what are you doing to solve this problem? Golf clap for asking the question, right? Yes, indeed. That is exactly what he stated. I transcribed it quite perfectly. And it's so good to see somebody just bring this point out to Gary, but of course he doesn't seem to give a damn. We all know the truth, though. The way that Gary wants to just rule over the asset class as dictator Gary, it harms investors and takes away financial opportunity and freedom. That's what it does. It's also not in line with decades of securities law, because there is not clarity. There is not clarity that what constitutes a sufficiently centralized or decentralized platform, which is core to whether or not something is a common enterprise. And it gets even worse than that, though, because although we understand that, of course, that makes sense if you're just looking at the law, the Howie case, we get that. Of course, you need to know. It's key whether or not something is centralized or decentralized. I haven't seen Gary Gensler even recognize that point since the time that he's been a chair of the SEC. He used to talk more openly years ago, before he knew he would be running the SEC one day, and he was a lot more frank. But now it's not even clear if he thinks that's a sufficient factor. So all I see here is that he has no care, he has no regard for the investors that he's sworn to protect, and deal with it. That's his message effectively. That's it. And he talks about fraud, this and that. My gosh, nobody is against you protecting investors in the cases of true outright fraud. But in the instances where there is no fraud, don't do things that harm investors, and don't regulate through enforcement, which is another thing that Mr. Emmer did bring up as he was speaking with Gary Gensler today. Man, this is the guy. This is why we can't have nice things. This is why we cannot have nice things. So, you know, I'm rooting for Deaton. I'm rooting for everything to go well for the SEC versus Ripple case here. And if we do see it fully adjudicated rather than settled, that would be better for the space. But hey, if we just end up with settlement, at least I'll know that my XRP is safe, because you can't bring, that's how it works in America. You can't bring the same charges up against somebody a second time. So once this is done, it's going to be completely finished one way or another, and we'll probably find out sooner than later. Perhaps if we don't see settlement, I mean, it'll still be the early part of next year, but who knows? The truth is, settlement could come at any time unexpectedly, and I'm hoping I just wake up one day and see that kind of, as much as I'd rather have, you know, a bit more clarity. Because like, even if we do this, and so say this all goes in the favor of Ripple and it's fully adjudicated. Okay, yeah, as much as I agree that would be better for the space here, it's still, so maybe it takes away power from the SEC because there would be precedent set, but they're still not changing their approach. And so you would still have a problem with them to some degree, the entire crypto asset class would. It's not they would just stop bringing the suits, it's just they'd have less power when doing so, and they might have to be a little bit more crafty in the way they word things. But it still wouldn't be like the, you know, the silver bullet to like just put an end to all of this. It would be better, and I'm with you. I think we probably all agree on that. It would be better for the crypto space, but it's not going to just, on its own, solve this problem. What a train wreck here. We just need different leadership. This is why we can't have nice things, folks. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.